Hello. Today we are going to be talking about negotiating and identifying the premises in commercial leases. And my name's Steve Blake. I'm an attorney. I'm the owner and managing partner at the Blake Law Firm. We are located in San Diego County in the city of Encinitas, and we represent commercial and residential property owners, landlords, tenants, lenders, etc. And with me today is Justin Walseth. Do you want to introduce yourself? Oh, you're on mute.
Thanks, Steve. My name is Justin Walseth. I'm a principal with Cresa Global Inc. We're an occupier services firm. We have 53 offices throughout the US as well as global offices. We work with tenants to facilitate all things real estate, from leases to build-to-suits and everything in between.
Great. So today's presentation, we're just going to touch on a few different things regarding premises under a commercial lease. What is the premises? Negotiating the premises before signing the lease, lease provisions regarding the premises, common disputes involving the premises, conclusion, and then any questions from anyone. So first of all, what is the premises? And Justin, do you want to just touch on how you see that as a representative of commercial tenants?
Yeah, absolutely. So in the commercial business, the premises can mean a lot of different things depending on the use, the type of building, the structure of lease, and the landlord entity. So it's important to make sure, depending if you're an office user, a biotechnology user, or an industrial user, what part of the premises are you going to be using, and more specifically, what part of the premises is exclusive to your use. So it's important to have a very strong understanding of what responsibilities fall under your lease provisions.
And for example, like a standalone building could be like I'm thinking of a restaurant that's just a standalone restaurant. And for that particular building, the premises may be the building itself, the parking lot, landscaping. Whereas if you are renting a space in a shopping center or an office building, your premises may be defined as just your actual physical unit, whereas the sidewalks, the parking lots, and all that stuff is not included as part of your premises.
Right. And, depending on how large the premises is, sometimes landlords have liabilities that they like to pass along to tenants. So it's important to understand conditions of the entire premises. For example, in an industrial single standing building, a tenant may be responsible for the driveways, the drainage systems, and many things they might not initially think they're responsible for.
So when a landlord and a tenant are negotiating a lease agreement and they're figuring out how to define the premises, here's a checklist of some of the things that they should be thinking about, whether they're talking to their broker like Justin about that or to an attorney. But the first one, exclusive versus non-exclusive use of the premises, we kind of touched on that just a minute ago, but Justin, do you want to explain how you look at that from your perspective?
Yeah, absolutely. Depending on the type of use that you have within your facility, that's going to determine if the premises is going to be an exclusive use. I'll give you an example. In a multi-tenant situation, a lot of times the premises will just consist of everything within your four walls. That is different than when you have a single standing building or an arrangement where you're maybe sharing a truck court or sharing drive aisles where you have further responsibilities beyond your premises that you actually end up having to pay for. So a lot of times that will need to be addressed when you look at common area maintenance provisions or triple net lease obligations that also include the taxes, maintenance, and insurance, as well as capital improvements.
And maintenance and repair obligations are very important when negotiating a lease because depending on how long the tenant is there, there could be a number of things that could go wrong with the building that require attention and maintenance. And so it's important to clearly state who is responsible for these items at the time of lease negotiations. And some of those things are reasonable wear and tear. Typically a tenant that is in a property for 10 years, there's going to be some scuffs and scrapes. And a lot of times that's not something that the landlord's going to make them pay for at the end of the lease term. However, something like structural repairs, if something goes wrong with the structure of the building for some reason, it could be a very expensive fix. And it's important to understand who is going to be responsible for fixing that. Is it the owner of the building or the tenant? And some of these other things like decorative aspects, mechanical systems such as the HVAC system or the plumbing or electrical, there could be issues with that. And again, it could be an expensive fix, and you want to know at the outset of the lease who is responsible for handling that. And then existing condition, do you want to touch on that one, Justin?
Yeah, sure, Steve. So the existing condition, when occupiers look at signing leases, is the most critical aspect of making sure you're completely aware of the current condition of all of the different elements of the building. To Steve's point, when you look at some of the structural aspects of a building in California, earthquakes are definitely a large hazard. And sometimes what will happen is that improvements will get damaged due to slippage or to old slabs or shifting of buildings. And it's very difficult to understand what causes damage, and making sure you're calling out in a lease, certainly with the guidance of an attorney, and making sure you pinpoint, things that could potentially go wrong, and having obligations on the correct parties is very critical. When we look at mechanical systems, in many instances, tenants will inherit a space with HVAC equipment in place. So understanding the age of the HVAC equipment, as well as the useful life remaining of the HVAC equipment, that could lead to really large cost items for tenants. And making sure that those are addressed at the onset of a lease is highly critical to saving costs on the back end when you vacate.
What is like the typical process if a tenant, before they sign the lease, if they want to check the existing condition of the building, would they typically hire like a contractor to walk the building, or how would they do that?
Sure. So when we look at these physical aspects of a building, we always recommend to have a building inspector come in and take a look at the building. These inspections can usually range between $10,000 and $15,000, but what it allows you to do is to pinpoint problems that may come up that may not be your responsibility, or at least you want to stay immune or stay away from having to pay for damages resulting from, a building that's already had a cracked slab, or HVAC systems that are going to expire. So having an HVAC contractor look at the HVAC systems before you sign the lease is a very important process to go through, again, prior to signing a lease.
One thing as well, when you're thinking about the premises, is the insurance, because typically your insurance premium is going to be based on the square footage of the premises that you're letting. So oftentimes, in your typical landlord tenant situation, the landlord's going to have an insurance policy in place. The tenant is going to have an insurance policy in place. And then there's typically a general business liability policy that the tenant's going to have. And then there's other things like business interruption insurance or auto insurance, like we talked about. These are things that make a difference depending on what the premises is. For example, if your premises is defined as including the parking lot and sidewalks and byways, your insurance premium is probably going to be higher, because it's a bigger risk to the insurance company to insure the parking lots and the sidewalks, as opposed to just the inside of the four walls of your building, like in certain other premises.
Right. We always, from an occupier standpoint, we always make sure the tenant is, our primary goal is to make sure that tenants can maintain a continuity of operations. Insurance provisions have a large impact on the outcome of a detrimental event that may stop you from operating in a building. So making sure that you have an attorney address, the circumstance if maybe a neighboring tenant causes damage that prevents you from occupying your own premises, those time periods are addressed in the, what the landlord's required to do to restore a building is addressed on the onset of signing a lease. Because you certainly don't want to be in a position where you can't occupy the space or operate your business in the event of a loss.
In commercial lease agreements, the provisions regarding the premises can vary quite dramatically. And here we just included a couple different things for the viewer to see, but a custom lease provision, this is something that's drafted by either the landlord or the tenant, typically the landlord. But as you can see here, they define the premises as shown on Exhibit A. So a lot of times what they'll do is attach an exhibit to the lease that is a diagram of the premises that shows the dimensions where the premises is. But then as you can see here, it also includes, all shafts, cable runs, mechanical spaces, rooftop areas, landscaping, parking facilities, private drives, etc. And, these are important. And a lot of times these are buried in big 50-page leases, and you might not pay attention to this, but something like rooftop areas, that's part of this premises in this lease provision. So if something goes wrong with the roof, this tenant may be on the hook for having to fix that or maintain it throughout the term of the lease. Do you want to talk a little bit about the AIR lease provision, Justin?
Yeah, absolutely. And a lot of times leases are, in almost all cases, leases are slanted toward the landlord because you're using a landlord drafted lease. So they typically like to cover everything under the sun in terms of liability and make sure that that's covered by the tenant. And it's also an important, tenants need to understand that the size and capability of the landlord will also impact the types of responsibilities that move to the tenant. So if you have a smaller landlord, it's important that, you need to negotiate a little harder on some of these items because they may be broad and far reaching, where you may need some more details to really define what the rooftop area actually is. Does that cover the downspouts and things that, for instance, if you're in an industrial building and there's tree debris on the roof, that could cause a roof leak. So the question is, who's responsible for the landscaping and how that could impact, potentially a liability related to a roof leak. The AR lease is a lease that's used especially in California, and many times it covers a lot of different types of facilities. So it's very important to hire an attorney and to make sure that you're reading through these provisions to understand what is actually the premises and making sure that your responsibility is fair based on market expectations and your business.
Yeah, and sometimes in these provisions, if the premises is loosely defined, or it just says, the premises is this address, and that's it. What does that mean? Is the address, does it go to the outside of the walls of the building, or does it go to the interior of the walls? Does it include the roof? So if a lease is vague as to what the premises is, it could cause a dispute later on when something happens, like Justin mentioned, if there's, a roof leak and who's responsible.
Right. And, one thing I would mention here is it's very important to have an attorney review the language of these provisions, because sometimes what will happen is that the language may intend to look like a tenant's responsible to repair, but a lot of times it's not so easy to determine who pays for such repairs or who pays for the actual aspect of the building that may need repair. So not only is it important to understand who makes those repairs, who's responsible for the repairs, but at the end of the day, you want to understand who actually has to pay for those repairs or those maintenance responsibilities.
Exactly. Some of the common disputes involving the premises, and this usually disputes about the premises arise, after the lease has been signed and the tenant is occupying the building, and something happens. And, some of the common ones that we put on here was, usable versus rentable square footage. Um, like I said earlier, sometimes in a lease, it'll just say, your premises is the address of the building. And it may say like, which is approximately 20,000 square feet. And the rent that the tenant's paying is based off that square footage. And once the tenant gets into the spot, maybe they determine that, hey, there's X amount of square feet that we're really not able to use for whatever reason. Should we be paying rent on that? And you go back and you look at the lease. Well, what does the lease say? And it says, you're responsible for 20,000 square feet. So it's important to understand what that usable square footage is at the beginning, because you want to pay rent based on what you're using, not on things that you're not able to use.
Right.
Do you want to talk about the failure to deliver the premises on time?
Sure. There's so many things that go into delivering a space and making sure that an occupier is aware of the condition of the space when they receive it and when they actually receive it based on landlord performing work. A lot of times we like to integrate provisions into a lease that have outside dates. The concept around an outside date is, say, a landlord should deliver you, or you have a scheduled lease delivery of January 1st. Well, if the landlord doesn't complete their work by May 1st, it's important that a tenant has an exit provision to get out of the lease if the landlord doesn't deliver the space as they've agreed in the lease agreement. One comment on the usable versus rentable. We do a ton of work, especially in the last 5 or 10 years, where a lot of multi-tenant assets have been traded between different ownership groups of the operating expense provisions of a lease. So it's important to understand what tenants' responsibilities are within those operating expense provisions. Because a lot of times what will happen is that a tenant will be responsible for paying their fair share as if the building was 95% occupied. And that can be a heavy burden on a tenant. If the building is only 40% occupied, those occupants are responsible for the operating expenses for the entire building. So having a general framework of risk when you enter into a lease is the right thing to do, and certainly an attorney can help figure out what your risk is as a tenant.
And damage to the premises, we've talked about this a couple times already, but to use the example, if there's debris from trees that fall on the roof and cause a roof leak, if it's not clearly spelled out in the lease as to who is responsible for repairing that and who's responsible for paying for that, then it could lead to a dispute. Sometimes these damages could be in the hundreds of thousands of dollars. So it's the landlord and tenant are going to take it very seriously in determining who's responsible for that.
Right. And, I always look at the management company as well. It's very important to review the management responsibilities at a building, especially in a multi-tenant building, to make sure that a lot of the capital assets of the building or things that need to be maintained are actually maintained. So things like driveways, if a driveway isn't maintained every 2 years, it can lead to alligatoring and it can lead to costly replacements. So understanding what your landlord's obligations are to maintain the facilities is very important, and understanding maybe what future capital repairs need to be made on a facility during your lease term is also another aspect to be looking at, in the onset of a lease.
Good point. And then lastly, this unauthorized improvements to the premises. And the way, to think about this is typically when you're a commercial tenant, if you want to make improvements to the premises, it's okay, provided that the landlord or the owner agrees to it and consents and signs off on it. And sometimes the landlord won't do that. And sometimes the tenant will make improvements without notifying the landlord. And if that happens, it could lead to a dispute. That the landlord may want the tenant to take down whatever improvements they made. For example, if you're a tenant in a building on the first floor and you have some doors that open to the outside, and maybe you decide to install a patio right there so that your employees can go out and have lunch. But that patio is in the common area, it's not part of your premises, and the landlord may not allow you to have that there. So that's one example I was thinking of. Anything that you can think of, Justin?
Yeah, this brings up one provision we see quite a bit, a restoration clause. So a lease will have a restoration clause that calls out the process that a tenant must go through in order to return the premises once their lease term is up. So making sure you're crystal clear on what's required when your lease expires. And then again, on the front end of the lease, making sure that you're aware of some of the costs that go into making improvements. A lot of times, landlords will integrate project management fees or oversight fees. In many cases, these are unneeded fees and disassociated with the actual size of the project that occupiers need to be aware of on the front end. So there's quite a bit of negotiation that goes into making sure you're clear with, number one, what you have to restore at a premises, and also, making sure you have rights to do specific improvements for your operation at the onset of the lease.
Perfect. Well, we've touched on a few of the issues that can arise when talking about the premises on a lease, and we're trying to keep this short for the viewer, but we appreciate all the attention, and thank you, Justin, for being here today. And if you want to get a hold of myself or Justin, our contact information is up on this screen, and we'd be happy to hear from you. So thank you very much and have a wonderful day.
Thank you, Steve.